Welcome to the latest episode of International Law Chats, or ILC for short, a podcast from the American branch of the International Law Association. The podcast airs on the first Monday of every month, and we hope you can join us each month for a new episode. I'm Chiara Giorgetti, a professor of international law at Richmond Law School and a non-resident faculty at the Vienna Diplomatic Academy.
And I'm Alison Macdonald, a barrister at Essex Court Chambers in London.
Welcome, everybody. This episode builds on a high-level discussion held at the CADI in Strasbourg, the meeting of public international law lawyers from the Council of Europe, which tackled one of the most difficult tensions in international law, the relationship between peace and justice. And the question that was asked then was, at its core, what happens when the people you need for peace are, under international law, the same people that must be arrested? And this is one of the hardest dilemmas in international law today, really. And it's really quite well exemplified in the context of Russia's invasions of Ukraine and the pending arrest warrant for Russia's President Vladimir Putin at the International Criminal Court. International criminal tribunals are built on the premise of accountability, but peace processes often depend on engaging those very individuals who are under indictment. So is this a clash between law and politics, or does it reveal something deeper about the limits of the systems itself? In this episode, we unpack and discuss the tension between peace and justice from a high-level legal principles to the realities of the negotiation rooms. And to speak about these fundamental questions, we have three fabulous guests. First is Ambassador Franz Perrez, who is Director of the Directorate of International Law at the Swiss Federal Department of Foreign Affairs. Professor Sarah Nouwen is the Chair of Public International Law at the European University Institute, on leave from Cambridge University. And Professor Dr. Andreas Zimmermann, Professor of International Law at the University of Potsdam and Director of the Potsdam Center of Human Rights. Franz, let me begin with you. Also because you confront these questions, I imagine, from a very practical point of view in your work as the legal advisor for Switzerland. And Geneva really has a long tradition of hosting peace and diplomatic negotiations. So let me begin with the big picture and lay the foundation. When we talk about peace versus justice in the context of international criminal law, is this truly a conflict, or is that framing maybe too simplistic from the perspective of a state?
Thank you, Chiara. And let me first thank you and Alison for hosting me and my colleagues here to discuss that question, which is really quite an important question. And just to respond to describe a little bit the complete situation, Switzerland was last summer proposed by President Macron and others, to host possible peace talks between President Trump, President Putin, and President Zelensky. So it was not Switzerland looking for that, but there was a proposal that Switzerland could host such peace talks in Geneva. And that has triggered once again the question, what happens if you want to host peace negotiations and one of the needed participants is a person against whom an arrest warrant by the ICC exists? This is not the new problem. There were similar problems were faced with Jordan, with al-Bashir, with South Africa, when they wanted to host a BRICS conference. And there it seems to be that on the one side, you have a clear ICC jurisprudence, which says that there is no personal immunity of the Troika, which prevents a Troika member when traveling, and that the member of the Rome Statute has obligation to cooperate on and to arrest such persons, independent of other legal obligations. But on the other hand, of course, there are also other legal principles, like the UN Charter, for example, who calls all its member states to promote peace and to support peace efforts and negotiations for peace. There might be host country agreements, like Switzerland has host country agreements with the UN, where we are obliged when hosting UN meetings to grant safe conduct and unity to the participants. There's also the UN Charter on special missions, which also obliges states, if they are having special missions on their territory, to grant de facto immunity to the participants. And there might also be something like a principle of safe conduct when someone is participating in peace negotiations. You don't host peace negotiations and then arrest participants of such negotiations. So there seems to be clearly a legal tension. between on the one side obligations towards ICC, and on the other side obligations towards the common objective to promoting and supporting peace processes. But I think if that is reduced to a conflict between peace and justice, this is probably a too simplistic approach. Because first of all, I think it is clear long-lasting peace cannot happen without justice, but justice can also not be happening without peace. On the contrary, if a conflict continues, that continues also crimes being conducted. And the Rome Statute as such is not a statute that promotes only accountability and justice. It also wants to prevent crimes, and in its preamble, it makes clear it should also contribute to peace. So I think it is important to find a solution that avoids that artificial tension, but that brings us these two objectives together. And I think there are also possibilities to do that, so that we don't have to see peace and justice as competing with each other, but as mutually supportive and complementary objectives. But what is important, that we do not embark on ad hoc approaches, but that we find a legal, conceptual framework, which is supported also by the ICC, to make it possible to pursue both objectives. And that's the reason why we are so happy that we can launch that discussion right now.
I wanted to follow up those observations with a question for Andreas, building on Franz's observations there. If we step back and we focus on the legal architecture, how would you say that international law currently conceptualizes balance between immunity, accountability, and peace? Do you think there's a coherent framework, or are we dealing really with a patchwork of principles?
Thank you very much for inviting me, and thank you for this interesting debate and question. I think we have to start from the very fact that it's high-ranking officials that commit the crimes, which we are talking, crimes against humanity, genocide, and war crimes. So from the very outset, there has been a tension between, peace and justice, given that it's those high-ranking officials that are committing those crimes. And in my understanding, this tension is being solved somewhat by a certain preference for criminal prosecutions, if we look at the Rome Statute. And therefore, we have, my understanding, to treaty-specific exceptions to those to this preference, and notably Article 16 of the Rome Statute, granting the Security Council with competences in the field, the headquarters agreements between states and the United Nations, which was already mentioned, and Article 105 and 103 of the Charter itself. So it's, I think, treaty-specific exceptions that should govern, and that do govern and regulate this balance between peace and justice.
Thank you, Andreas. Sarah, let me bring you in the conversation. Your work often challenges kind of the dominant narratives. Let me ask you then directly, do you agree with the framing? Do you think that there is the idea of a peace versus justice? Is the dilemma itself? How otherwise maybe constructive or maybe misleading? So in a specific question, are we asking the right or the wrong question here?
Well, thank you so much for inviting me to be with you today. And I think after that introduction, I would be really disappointing if I did not challenge the idea. But rather than challenge the idea up front, let me say something about why the slogan often elicits such strong reactions. So some people are strongly against the statement because they say it unnecessarily presents a binary choice, peace or justice. Some people support the statement because it reflects a tension that they have experienced or observed in practice, a tension that needs to be recognized and addressed. Now, the issue is that both sides are right. And that is because the slogan, peace versus justice, in the abstract, is so all-encompassing that one can mean very different things when one invokes it. And that's why the two sides often talk past each other. For example, those who are against the statement argue that it's wrong because, and I mean, this is one example, true peace, as they say, encompasses justice. Now, in that approach, peace is interpreted so broadly that any tension is defined away. Or it is argued that justice need not mean criminal justice, which is true. We can also speak of restorative justice, distributive justice, or accountability without criminal punishment, in which case detention is again defined away. But as the framing of today's conversation clearly indicated, today we're talking about in the context of international criminal law, so we cannot define it away here. Even in the context of international criminal justice, and with peace being defined narrowly as the absence of physical violence, people who are against the slogan point out that peace and justice should go together, and in many cases do go together. For instance, in many countries, we would consider criminal justice as an instrument to support the internal peace. However, the real problem that the slogan peace versus justice tries to get to is not about this end state. It is a transitional issue. How does one get to that end state? In other words, it's not the goals, peace and justice, that are irreconcilable. It is that the logics of their pursuit can in some circumstances clash. Now, in that case again, opponents of the slogan will point out that the pursuit of peace and justice need not be in tension. For instance, in situations where one side totally defeats the other, one can easily pursue both peace and justice at the same time. Think Nuremberg, Tokyo, post-genocide Rwanda. Peace versus justice, then, presents itself primarily when there is no total victory yet, and one wants to avoid the loss of even more lives through a negotiated settlement. And this is the situation I think that Ambassador Perrez focuses on. Now, even in that context, opponents of the slogan will argue that it's a false slogan, pointing to situations where alleged war criminals were deemed unnecessary for the peace negotiations. Think about Karadzic and Mladic, who were not invited to the Dayton peace talks. But this was a situation in which the peace mediator, the US, was not merely a go-between between the parties, but it could coerce the parties to come together, and subsequently, through NATO, enforce the peace. The real tension of peace versus justice, then, manifests itself in a situation where there is no mediator willing or able forcefully to bring parties together and to enforce the peace. Finally, we need to differentiate between peace versus justice as a substantive issue and as a procedural tension. Substantively, the tension has manifested itself most clearly in negotiations between governments and rebel movements. Why would rebel movements subject themselves to the legal order that they've been resisting and that is controlled by their opponent if they will be rewarded with long sentences? Today, however, we focus on the procedural aspect of the tension. How can one even bring parties together to talk if the legal order hosting those talks is under an obligation to arrest key actors in those talks? In sum, there are specific situations in which the slogan peace versus justice does make sense, not to present a set of binary choices, but to reflect a real tension.
I'd like to switch now, going back to Franz, to focus on the operational framework, and with those helpful observations from everyone in mind, to make this concrete. And so I'd like to ask you, how do states navigate situations in practical terms where they are under a legal obligation to cooperate with an arrest warrant, but there is also a real opportunity to advance peace negotiations?
Thanks, Alison. Well, this is a tricky question because I think states are faced or could be faced with a dilemma. If we wouldn't be able to find a procedural way, as Saros is outlining, that is able to bring the two objectives together, then states would be faced with a dilemma either to comply with a cooperation obligation under the Rome Statute or to comply with a broader obligation on the UN Charter to promote and support peace processes. And I think what we as states can do, we have really tried to find a way out of that dilemma so that it is not a binary question and that we are not faced with a binary question either to violate this obligation or that obligation. And I think there are three ways to that. One would be just to say simply, well, we as a state, we as Switzerland, we are convinced that the obligation to promote peace is not in contradiction to the obligation to promote justice, and therefore we go along in supporting peace negotiations independent of what ICC say, but I think that is not the satisfactory way forward. Another option is, of course, to try to further push a better understanding, a conceptual legal understanding of the situation by having interaction with other legal advisors of different states, but also by involving the academia in that thinking. And the third way is the approach that is outlined by the Rome Statute. I think the Rome Statute says if there is a concrete situation of a problem between your obligation to rest on the one side and other legal obligations you might have as a state, then you enter into consultations with the ICC. And I think that is the way which we would do. If there would be a concrete situation, we would enter into consultation with ICC. But in order that these consultations can be meaningful, I think it is important to better understand conception, legally, all the different nuances that are involved on the one side. And it's also important to understand that this is not only something that is relevant for Switzerland or whoever is going to host peace negotiations. This is also absolutely critical for the ICC, because the ICC should not be locked into a situation where it is asking its member states to act in a certain manner that are clearly not in line with the overall objectives of the international community. So I think that is also something that we need the ICC and help the ICC to find a solution out of the situation which could be deadlocked.
Thank you very much, Franz, for these very practical observations and concrete examples. So let me ask you, Andreas, maybe we can help also in this context and in the same really operational context. Where should the line be drawn between the necessary flexibility for negotiations and the risk of sliding into impunity?
Well, I think we have to look for concrete provisions of the Rome Statute, notably, which could provide us with some guidance where the kind of substantive standard lies. And I'm thinking about, for one, Article 53 of the Rome Statute, which says that when it's in the interests of justice, prosecution could be stopped. Interests of justice. That would be one provision that is certainly relevant. And the other one would be Article 16, as we all know, which provides that the Security Council could, at least for a period of 12 months, interrupt a criminal investigation if the council were to act under Chapter 7 and consider that any such criminal investigation or prosecution could endanger international peace and security. So for one, the interests of justice, and for other, it's possible threats to international peace and security emanating from such criminal investigations. And we have to kind of sail in between those norms, like between Scylla and Charybdis.
Turning to Sarah now, still looking at the practicalities here and what they mean in reality. If we look at how arrest warrants and cooperation obligations play out in practice, do you think that these decisions operate neutrally, or do they risk reinforcing political selectivity and existing power imbalances? So, and in that light, how should we see the recent and current practice of the ICC?
Yeah, just to take a step back. I mean, we all know that the ICC has been facing criticism of political selectivity since the beginning. And for instance, critics pointed to selectivity in which situations investigations were opened and where not. Now, the initial focus on Africa meant, for instance, that the ICC gave the impression that the most serious crimes of concern to the international community as a whole, as I quote from the Rome Statute, were committed by Africans, a situation that may be defendable from the perspective of focusing on individual criminal responsibility, but is more problematic if one sees that the ICC is involved in the global distribution of blame. Now, that selectivity has been somewhat addressed. We now also have arrest warrants for people in Russia, the Philippines, Afghanistan, Israel. But as an aside, when I yesterday looked at the court's website with all its defendants, all pictures are still of people of color. There are no pictures of Russians or Israeli defendants. Now, it's unclear on what basis decisions are taken whether or not to upload an image of a defendant, but the optics undermine the actual diversification. Critics have also pointed to selectivity in which side of a conflict was targeted, government or non-state actors, and where complementarity was given a chance and where not. Now, to go back to the peace talks, we can note that the Office of the Prosecutor and judges have given peace talks, think about Uganda, Colombia, a chance or more of a chance prior to the issuance of arrest warrants than once arrest warrants were out. In the context of our topic today, one area that actually merits further study, but it's very difficult to access on the website, is whether the ICC only issues an arrest warrant or also accompanies it by a request for cooperation and sends that to all states. Because that too can show a type of selectivity. For some people, immediately the request for cooperation, which is actually the source of the legal obligation, the arrest warrant in and of itself is not, is immediately issued to all states, and for some people actually not. Now, selectivity can of course be explained by institutional interest, or at least self-perceptions of institutional interest. And here, it really matters how states react to the ICC's action. And there again, we see forms of selectivity. For instance, Western states remained very quiet or even cheered when the ICC appeals chamber told African and Arab countries that they were legally obliged to arrest President Bashir on the ground that he didn't have immunities. Even though some African states made the case, as Ambassador Perrez also said, that he was necessary for a peace process. Western states also remained silent or indeed cheered when the ICC issued an arrest warrant against President Putin. However, when the ICC issued an arrest warrant for Israel's Prime Minister Netanyahu, some Western states suddenly began to question the ICC's immunity jurisprudence. Now, this is not to point out double standards. We all know that they exist, but it is to point to the consequences. Because many people who will, when they now hear, for instance, in the Global South, that suddenly the West is worried about peace versus justice, they may think that this is to protect, for instance, Netanyahu, because of the Gaza situation, rather than that it is about a more general concern about peace versus justice.
Thank you. Let's focus more specifically now on the available legal tools. And Andreas, to you specifically, you mentioned already the possibility of deferral, and there are other legal tools that exist, like the debate also around immunities. Do you think this mechanism that exists within the system, do they offer a real solution to this tension, or are they ultimately limited?
Okay, let me start with the issue of immunities. I mean, we're all well aware, and we'll just mention the constant the jurisprudence of both the appeals chamber and of two pre-trial chambers of the ICC, confirming that there is no head of state immunity, and the same would apply mutatis mutandis, obviously, to other members of the government, Minister of Foreign Affairs and so forth. And I don't see the court changing its jurisprudence. I think it will cling to this very strict outline of not accepting that there will be some form of immunity. So whether we like it or not, we kind of stuck with that. Now on deferral Article 16, it was a deliberate decision when the Rome Statute was negotiated to very narrow exception only, a very narrow possibility of a deferral. That was a deliberate decision by the negotiating states. And we all know that 3 of 5 permanent members of the Security Council are not contracting parties of the Rome Statute, notably the United States, Russia, and China. And I don't now see the Council under those circumstances make use of Article 16, because it would implicitly mean that the Council would accept some form of legitimacy before the International Criminal Court, which for the US, the Russian Federation, and China is probably a no-go in those years. So unfortunately, neither the jurisprudence of the court on immunities nor Article 16 seem to provide any way out of this dilemma we are facing. So as mentioned at the outset, it's rather on the basis of headquarters agreement or Article 105 of the Charter that we have to focus on to get around the issue.
Carrying on those thinkings about those thoughts on the practicalities and turning back to Franz, from your perspective, do you see states relying more on formal legal tools, or are they managing this tension informally through kind of political practice?
Well, I think we shouldn't see formal legal tools and political practice as opposing ways how to proceed, because law at the end is on the one side the clear treaty law, but law is also customary law, general principles law. Law is also a crystallization of political practice. So I wouldn't say that there is a total tension in between, but there could be situations where we would have clearly conflicting interests or tensions between obligations, between political visions and objectives. And then, of course, it will be difficult for states to take a very narrow, formalistic legal approach, which is blending out other elements which are also part of the legal system. So the ICC, the Rome Statute, is not a legal regime in isolation of the rest of the world. And I think it is important that we always see that these legal systems have to work together, the legal obligations have to work together, and that we have to find a political practice that is in line with these different legal obligations. And if there is a real conflict between legal obligations, then there are rules of conflict, how to address that, and we need to find ways to go through that. I would like just to take up two points. One made by Andreas, the distinction between the immunity of the Troika and peace talks. I think that is really important. I agree with him that the jurisprudence on the Troika immunity is pretty clear, and we do not expect and also do not want to change the ICC to take this jurisdiction. That is now the law has evolved into that direction, and we always support that, and we would not criticize or challenge that. But a real situation where we had real narrow peace talks, I think that has not yet happened so far. So far, these cases have also been involved peace talks and political considerations. So I think that is something where we do not yet think that ICC is bound by a precedent. I would also like to quickly pick up the issue of double standard. I think that was made by Sarah. I think, yes, double standard exists and they have to be deployed, but we should also not always see double standards. For example, when it comes to the ICC, Switzerland, like many countries, we did not applaud the arrest warrants, neither the one against Putin nor the one against Netanyahu, simply because we think it's not us to applaud steps taken by the ICC. What we have to do is to support the impartiality, the integrity, and the independence of the ICC. So we can support ICC, but we shouldn't comment its decisions. We trust at ICC that these decisions in both cases were legally sound to initiate these proceedings, and we also trust ICC that the decision at the end will be a correct one. So there are not all states, there is not always these double standards are happening, and we have really tried to focus on avoiding double standards and not highlight whenever we have a perception of possible double standards. That's not bringing us forward.
Thank you, Franz. Sarah, to you then, how do you see this evolution? Maybe going back with your academic hat and looking at maybe at the theory, do you see this evolution as strengthening the system through this flexibility? Or you mentioned double standard. Is it flexibility? Is it double standard? Or does it undermine or does it undermine by maybe normalizing these exceptions? How do you see it?
So I think it really depends on how the exceptions are invoked. As long as, or at the moment that it's done within argumentation provided by the Rome Statute, one way or the other, it strengthens the system. It's legal argumentation. It acknowledges the existence of the law. The moment that states start bypassing the whole legal framework to facilitate peace talks, there is a problem for international law. And I actually think that then there's also a problem with international law, because peace is a fundamental value of the UN Charter, and peace is also recognized increasingly as a fundamental human right, as a precondition for other human rights. And I think here it's inspiring to think about what Judge Diego Garcia Sayan wrote in a separate opinion in the El Mozote case in 2012. Now, that case was about El Salvador, but in 2012, the peace talks in Colombia were just taking off, and he wanted to send a clear message that international law supported these peace talks. He wrote, and I quote, "Peace as a product of a negotiation is offered as a morally and politically superior alternative to peace as a result of the annihilation of the opponent. Therefore, international human rights law should consider that peace is a right and that the state must achieve it." Now, for international law to have bite, it requires institutions. And I think international criminal justice really took off thanks to the establishment of international criminal courts. In the context of Article 53, which Andreas has mentioned, which allows the prosecutor to refrain from pursuing an investigation or prosecution in the interest of justice, the Office of the Prosecutor has stated very clearly that it says, our duty is justice. Others are responsible for peace. Now, that institutional argumentation may work in a situation where the Security Council functions, but at the moment, I don't think we can say so. And I think that's why this very strict institutional line is a problem. Now, I note that this policy document is from 2007, so it's almost 20 years old. And it's one of the very few policy documents that hasn't been revised yet. So perhaps that's one of the first things that needs happening.
So, turning now to some forward-looking thoughts, and coming back to Andreas and where all of this is going to go, do you think that the current legal framework, particularly within the ICC system, is flexible enough to accommodate these different tensions that we've been talking about? Do you see the tensions being resolved through clearer legal rules? Or is this an area that will always have to remain politically negotiated, kind of case by case?
So, well, in my understanding, the power and of the court relies really on its legitimacy, and that in turn relies on being perceived as acting in a legal manner per se. And I thus strongly believe that the court should not opt for some kind of political maneuvering, somewhat à la tête du client. And to provide just one example, when the OTP stopped the investigations in the Afghan situation against US nationals, that, in my understanding, the person. So, so political decisions have to be made. Some other actors should do it. So, for example, one could, consider contracting parties of the Rome Statute, acting within the framework of the Assembly of States Parties, adopting some kind of document where they would address that tension between peace versus justice, where they would, by way of subsequent agreement within the meaning of Article 31 of the Vienna Convention on the Law of Treaties, provide the court with guidance how they, the parties to the statute, perceives that interaction between peace and justice. And that would be obviously a political decision. I'm not sure it can be reached. Such a document could be adopted. But that would then inform eventually and would provide, guidance for the court and also provide political backing for somewhat then addressing that issue. So that would be the way to go in my understanding. But the court itself should not try to adopt a more political approach to the matter.
Thank you, Sarah. Back to you, and again, looking forward. If you were to move away from, and maybe going back also to the first question that I asked you, if you were to move away from the peace versus justice framing, how do you think we should be thinking about the relationship between the two? Is there a better way to understand how they interact in practice?
Yeah, I think what I tried to outline in the answer to the first question is that we need to be much more specific about whether and where the real tension is in a concrete situation. And that procedurally can be, talking a lot about that, being under a legal obligation to arrest while wanting to host someone for peace talks, or substantively wanting armed opposition to reach an agreement with the government, or wanting a regime, think about Venezuela at the time, or think about Israel, to give up power, versus there being no incentive for the relevant persons to do so if the price for them is imprisonment or worse. So I think what the other thing we need to keep in mind is that tension plays out differently in intrastate and interstate conflicts. And I think that the tensions are actually worse and more pronounced in intrastate conflicts than in interstate conflicts, simply because people have to live together. And they're not, and in interstate conflicts, they are apart from the international jurisdiction, not subject to the same jurisdiction. Now, the other thing I think that is really important to center when we're discussing this is to listen to those who are most affected by the conflict. They often want violence to end. They want to know the truth about what happened to their loved ones. They want people to be held to account, but that need not mean long imprisonment all the time. They want reparations in order to regain some agency over their own lives. Now, many of these demands are framed in the language of justice, but none necessarily require what has been the end goal of international criminal justice, namely punishment.
Thank you. Thank you. Let me bring you into conversation now with each other. Do you think that the tension that we identified can be ultimately managed within the current legal framework, or are we heading towards more of a maybe the obligatory fragmentation from where political necessity openly maybe overrides legal obligations? Can I ask Franz to answer first?
Thanks. Well, I am convinced that we can resolve that conflict. First of all, also because of the flexibility that the Rome Statute is providing. Andreas was already referring to Article 16, but you have also Article 53(4) that gives possibility to the prosecutor to reconsider arrest warrants before or continuation of asking for arrest warrants. We have Article 58(4) that allows a pre-trial tribunal also to decide to end or interrupt certain proceedings for a certain moment. I think we are not faced with a binary choice. There are many options to reconcile. I think what is important, and then of course also what Andreas just was saying, that there's also possibilities by the member states of the Rome Statute to give guidance to the court through an ASB decision. But that needs further assessment, further analysis, input also from legal thinking, academia, think tanks, and so on. So there are many possibilities. And then we have also that consultation procedure, which is established by the Rome Statute, that when we as a member state are confronted with a problem, that we can consult. However, this consultation procedure have to be real consultations. I think South Africa, after their experience with their consultations, they rightly complained that felt that this consultation with ICC were not real consultations. They sit together and try to find the solutions. This is a judiciary proceeding where the state who is facing a problem is sitting on the bench of where normally the accused, the criminal that might have committed atrocity crimes, is sitting in front of the pre-trial table. These are not consultations. This is a judicial proceeding. But what we need is real consultations where we discuss with each other and try to find a good solution out of that dilemma. Because what Sarah was saying is important. We should stay within the procedures and we should follow the procedures and use the possibilities and avoid simply just unilaterally politically based decisions based on ad hoc assessment of a situation. We need some guidance, but in order to get that guidance, we need a constructive engagement and setting from all parties involved.
Thank you very much. Andreas, what do you think about the same question? Do you have any issues, any reply?
Yeah. I mean, the Rome Statute is a legal instrument par excellence. And I think we should really keep the debate in legal terms and find a legal solution to the issue we are being confronted with. To simply set legal considerations aside and now focus, well, we have to find a solution, so let's go for a political compromise. That would really set a very, very bad precedent, not only for international criminal law, not only for the International Criminal Court as an institution, but also for other areas of international law, generally speaking, where we are facing situations where states simply disregard international law by saying, well, but there's a political necessity, well, somebody has to do the dirty job or whatever you call it. And that simply cannot be done, in my understanding. It should not be done, because that would really undermine the very foundations of what this institution, the International Criminal Court, is all about. I mean, the ICC is a baby of the 1990s, as we all know, of better times of international law. But I think keeping that institution alive and keeping its legal foundations and the fact that it's being governed by legal considerations only alive is essentially is really essential, not only for the institution as such, not only for international criminal law, but also very important as a symbol of upholding international law as such, in my understanding.
Thank you very much. Sarah, what's your view on this?
Look, as we know, international law is a language. It's a language for argumentation, for making arguments. And we've seen over the past 20 years that the International Criminal Court has constructed and interpreted its statute, the Rome Statute, in particular ways that, unsurprisingly, I think reaffirm the professional biases of international criminal lawyers, right? That peace is best achieved through prosecutions. And that peace is the responsibility of other types of peace is the responsibility of other institutions. Now, that's one shaker of the interpretation. The other shaker of interpretation is institutional interest. And I think Andreas's example of the one instance in which Article 53, the interest of justice, was invoked, and thankfully, I would say, also overturned later on. But it really reflects that the court suddenly thought, well, it's not in our institutional interest to be meddling in Afghanistan because of, and I mean, the argumentation was slightly different, but you can read that into it. That was an interpretation of institutional interest, and that was actually overturned because ultimately it would undermine the legitimacy of the court. Now, I think we already see shifts happening. For instance, on complementarity, there's much more leeway for positive complementarity now than there was 20 years ago. And I think that's because the ICC recognizes that it is necessary to begin reinterpreting certain principles and approaches that it has had. So I think there's an opportunity also for peace.
I want to, we could continue this discussion much longer. It's extremely interesting, but we have to wrap up. And so I'm going to ask each of our guests in one sentence. I'm going to start with Sarah. What is the biggest misconception about peace and justice in international law?
I think that the biggest misconception is that justice, in our title, for today, Rethinking International Justice, necessarily means criminal justice. So much more justice needs to be done. Justice in the sense of truth, accountability, restoration, redistribution. And the pursuit of peace and justice would be more easily reconcilable if criminal justice were not the loudest actor.
Franz, what would you say is the biggest misconception?
Well, I would say the biggest misconception is a perception that justice and peace should or could or will be mutually exclusive because they need each other. I think a sustainable peace is not possible without justice, and I agree with Sarah, there are many ways how to realize justice, but justice is also not possible without peace, because without peace, the crimes and injustice will continue. So we really have to see them as mutually supportive and complementary objectives, and we have to find ways to realize them both.
And Andreas, final words here.
Well, for me, maybe the biggest misconception is that this, the tension is not already been addressed in the Rome Statute. I believe it is already been addressed in the various norms that address it, 53, 58, Article 16, and that we should deal with the Rome Statute as such and try to interpret those norms to bring about an harmony to the extent possible between peace and justice.
Well, wrapping things up on that note, huge thanks to all three of our brilliant guests for such an interesting discussion. I really enjoyed this conversation, and if our listeners have to, you can join us on the first Monday of every month for more international law chats. And as always, thank you to our amazing podcast producers, Laurie Farid and Freya Doughty-Wagner.